sometimes as a judge it's my responsibility to look the facts square in the face and call them like I see them. And so this isn't just a rape or a statutory rape. This is a rape of a very young little girl between the ages of 11 and 12 years when the crimes took place. These facts are simultaneously some of the most heartbreaking and abominable that I have seen in my years as a judge and as an attorney. Frankly, this is one of the most odious cases that I've ever presided over. I wanted to be very careful and systematic in my approach to this matter. I very carefully reviewed the recommendations. I would note first that I've reviewed the defendant's record, and the defendant has no prior record, which is something that needs to be noted for the record. And so much of what I know about the defendant's needs and issues are identified in the psychosexual evaluation. And there are some concerns evident in that report. First of all, there's a test in that report known as the VRT, the Visual Reaction Time Test. It's an objective test that's used to determine what a defendant's primary sexual interests are. And that test, although it did show that the defendant had certainly age-appropriate attraction to adult women and older adolescent women, it also showed primary sexual interest in school-age girls under the age of 5 and school-age girls between the ages of 6 and 13. That's an objective test. And I know the defendant has noted an objection, but the psychosexual evaluator's report indicates that the defendant himself indicated that not only explicitly through his own words that not only did he have those same interests in young underage girls, but also preschool age and school age boys. So there's some things going on here that are very, very bad and of great concern to the court. I note that the polygraph results indicate that the defendant was not able to produce a completely non-deceptive response to the questions. The one question that he couldn't get a non-deceptive response to is the question, is this your full sexual history? And so although objectively, based upon things that the defendant has said, he indicates there's been no other victims, we can't know that for sure based upon his answers on the polygraph, which showed deceptive. The defendant's approach to this crime and his response to it and his description of it himself, I think, is very illustrative of some of the problems here. He suggested to the polygrapher that the defendant's victim assented to the crime because she didn't resist his advances. At other times in the reports, he suggests that she initiated things. The story is different in different places, especially between the victim and the defendant. The victim's report suggests that the defendant came into her room often late at night while she was sleeping. This happened, unfortunately, on way more than just one occasion. That she would sometimes awaken seeing him leaving the room, dressing himself or pulling up his pants, and she would notice that she was partially disrobed and that she was wet in places she shouldn't be. I'm inclined to believe the victim's version of the events. She has no motive to lie. This has done nothing but humiliate and embarrass her. She has no reason to cover what's happened any further by trying to make it sound worse than it was. The Gain evaluator noted that the defendant appeared deceptive, that he appeared to be dishonest about what happened and about actually impregnating the girl. And that, of course, is part of this issue that makes it very concerning. This, first of all, was a very, very young girl, only 11 years of age when this started, and 12 when it ended. When this was finally detected, she was, I understand from the reports, 27 weeks pregnant. That's almost 6 months pregnant, approximately 6 months pregnant. It's concerning to the court that how this could have gone on so long without detection, and I have some very serious concerns about that. This ultimately was brought to the attention of law enforcement, apparently when a brother reported the situation to law enforcement. There are comments in the report that the mother and grandmother noticed that she'd been gaining weight and that they may have had some suspicions. It just breaks my heart that if there had been any suspicion of this, that why there wasn't action taken sooner. Again, this is simultaneously one of the most heartbreaking and abominable matters I've ever had to deal with as a judge. And I just feel like there might have been quite a few people that failed this young girl. The defendant's now 32. He was, I assume, a year or so younger when the crimes took place. The victim was 11 and 12 years old. 20-year age difference. There's just no way that can be justified legally, morally, culturally, or in any way with a child that young. And then you have the second factor of that is that this child was his stepdaughter. When a woman remarries when she has kids from a prior relationship, she puts a lot of trust in her husband, her new husband, that he'll protect and look after those children as if they were his own sometimes. Never in her wildest nightmares would she expect that the children would be abused. And this abuse of a trusted family relationship is very serious. I'll come back to that point later. In addition, the nature of the crime is serious because of the number of times this took place. This wasn't a one-time lapse of judgment in which somebody just let things get out of control and made a regrettable decision. That does not describe this case. This happened frequently, it happened systematically, over and over. Court can't ignore the fact that this act resulted in the pregnancy of a very, very young child. And when I say child, I think 11-year-old qualifies as a child under any definition. I don't know the victim very well. She hasn't been to court and hasn't made a victim impact statement. But I know enough about the world to know this. I know that an 11-year-old girl's dreams for her future don't include getting pregnant by her stepfather. Now, the second point in aggravation is the position of trust. Again, as a stepfather, the defendant was in a position of trust. Apparently the mother was ill, so the daughter had to take on some extra responsibilities in the home. And again, the very fiber of our society is adversely affected when these type of things happen. And the position of trust that the defendant found himself as an adult, caring for young children, meant that he was responsible to take care of them, not to exploit them, as happened here. The defendant's own comments are the third factor in aggravation, which concerned the court greatly. At times in his statement, he appears to blame the victim. He seems to suggest that she initiated contact, or that she wanted this to happen. Let me be very clear, I don't believe those accounts. But even if I take those accounts at face value, and I believe that the victim facilitated this, and again, I want to be clear, I don't believe that. But even if I did believe that the victim facilitated that, that in no way is a defense to this action. As a society, we understand and recognize that adults have a responsibility to protect children. Sometimes they need to be protected from themselves. And that duty to protect children means that we don't exploit them or take advantage of their weaknesses. So although I'm not buying the argument that the victim may have somehow sought this out, I just don't believe that. Even if I did, it makes no difference, and the factors that I have to apply in aggravation are very serious. The defendant also appears to place some blame on his wife due to her illness, and because she was ill, she may not have been as available to him sexually. And so that's what left him weak and more prone to this type of behavior. I can't accept that as a reasonable explanation or defense to these actions either. If I were, that would open a nightmarish Pandora's box for misbehavior for other defendants in the future. The fact that your wife's ill doesn't justify you abusing her daughter. It doesn't in this case, and I can't imagine any case where any judge would conclude otherwise. Finally, although the defendant has expressed some remorse and has indicated he feels bad and has apologized to the court, I haven't really heard him express much remorse for the victim. Again, I can't even begin to understand as an adult man the horror for an 11-year-old girl to discover that she's pregnant with her stepfather's child. And the pain and difficulty of someone so young and immature and carrying that child full term. It's just incomprehensible to me, frankly. The little amount that I can comprehend is certainly terrible. And no young person should ever have to live through that. As I said before, an 11-year-old girl's dreams and hopes for her future certainly don't include this. The defendant in the pre-sentence report made the following comment, quote, "What happened is what needed to happen, but I don't know how it happened." I can't think of a statement that I could disagree with on more levels. What happened was not what needed to happen. It should never happen. And the comment that he doesn't know how it happened is unacceptable to the court. He knows exactly how it happened. We all know how it happened. The defendant didn't exercise self-control. He let his feelings and emotions overcome his judgment, so that he exploited one of the most important relationships in life and ended up harming in a very real way a very, very young person. Whatever I do in my sentence with the defendant in this case here today won't take away the very real scars that this young woman is going to bear for the rest of her life. Hopefully she's young and resilient and will be able to get on with her life and find happiness and productivity and joy in the rest of her life. But there will be a part of her that was lost. 7 years of her innocence lost as a minor at the hands of the defendant. So after considering the very serious and terrible nature of the offense, the court has had to consider what sentence would be proper. And I have to do that based on the evidence. I have to do that based upon the circumstances. The court is mindful that because the defendant is an undocumented alien, that if I simply put him on probation, he would be immediately deported. There are some that would find such a solution tempting. After all, why should the Idaho taxpayers pay to incarcerate this man? However, this court does not believe that probation and immediate deportation is an appropriate sentence for several reasons. First of all, assuming the court were to do that and the defendant were immediately deported to Mexico, I would be putting young children in Mexico at risk. And their lives are not any less precious than the lives of our children here. And I, in good conscience, cannot do that. Second, if I were to place the defendant on probation and immediately deport him, there's nothing really stopping him from coming back to the United States at a future time. And he would basically not be held accountable for his actions. So again, that just does not seem like a proper or seemly resolution of this matter. So, after considering the facts in this case very carefully, the court's decision is going to be as follows. The court is going to sentence the defendant to a total unified sentence of 32 years. It will consist of a fixed minimum term of 10 years and will be followed by an indeterminate term of 22 years. The defendant will be ordered to undergo sex offender treatment while in custody of the Idaho Department of Corrections. The court finds that this sentence is appropriate after reviewing the factors set forth in Idaho Code 1925-21.